Honorable House Chairperson, as we consider the Performers Protection Amendment Bill and the Copyright Amendment Bill sent back to Parliament because of reservations by the President on its constitutionality and compliance with international treaties, the ACDP would like to place on record our appreciation for the tremendous amount of work done by the committee members, legal department, and all committee officials involved. These amendment bills seek to modernize our copyright and performers legislation as a template for standardization in our region, as well as to bring them in line with international treaties and best practice. They also seek to balance the rights of the originators or artists with those of the users, while simultaneously giving support to the creative and commercial success of South African art and artists. The ACDP, however, shares the concerns which have been raised by certain interest groups regarding the shortcomings of these bills, which includes but is not limited to the following. Firstly, the Performers Protection Amendment Bill, Section 3A, subsection 3B, refers to equitable remuneration, understood internationally as referring to the mere right to remuneration instead of exclusive rights. We believe that instead reference should be made in the provision to appropriate remuneration and as well the form that remuneration should take. Additionally, Section 5 of the Performers Protection Bill, referring to the downgrading of performers' rights from exclusive to mere remuneration rights, proposes levels of protection for certain performers' rights which are less than the requirements of the WPPT, which South Africa intends to ratify. On the Copyright Amendment Bill, the ACDP believes that the introduction of fair use as opposed to fair dealing could potentially plunge the South African online market for creative works into legal uncertainty, increasing the risks of litigation, as well as creating entry barriers for new services and creators. It must be remembered that in the United States of America, fair use has been developed over a period of 150 years of jurisprudence, while South Africa does not have this case law history or experience. And finally, concerns were raised about the regulatory impact assessments that needs to be done. And the ACDP agrees that in the absence of an assessment on the economic impact of the Copyright Amendment Bill, this relates to a material deficiency in the legislative process. The ACDP does not support these amendment bills. Thank you.